One of the least well understood topics is often privacy. Almost immediately, most people will tell you when they are asked about what do you think privacy is that they feel that it means that their personal data is secret, or at least confidential. And that's not what privacy is all about. Privacy comes into place where you, as an individual, know what information is collected about you and that you have the ability to control what is collected and what is done with that information. So it's not so much about keeping things secret, although that is a big part of it. It is about you knowing what information about you exists, who has it, what they have, and what they do with it. Privacy is a very hot topic, and it's also approached very differently depending on where you are in the world. Arguably, the European Union is the most advanced in addressing privacy. As a matter of fact, in the EU, privacy is written into their constitution. Here in the United States, we're almost on the opposite end, where as an individual, businesses can collect information about you and don't have to tell you, under most circumstances, what information they collect or how they use it. Government is subject to rules and regulations, but private industry is barely so. Other parts of the world, of course, are even less favorable towards individual privacy. But that's a political discussion and not one that we need to have here in the scope of cybersecurity. So for us, the fact that we need to know what information is being collected is important. What we also need to know is that for whatever reason, someone wants to be able to control what information they have. Again, I'm going to talk somewhat specifically towards the US perspective, since that is where I am located. And again, this is not legal advice. So privacy is widely discussed. And of course, when we're looking at what those principles of privacy are, there are many different standards to choose from. One of the most well-known ones is probably the privacy principles set out by the OECD, the Organization of Economic Cooperation and Development. It is a global organization between governments, and their goal is, well, the name kind of says it, to stimulate world trade. And so they have something to say about privacy as well. And so they list 8 principles, and they hope that their members, which include the United States, will actually codify those principles into law. That has been done with various degrees of freedom. So the first principle is an important one, which means that collect only that information about individuals if they know what you're collecting and if they consent to it. Keeping in mind that from a cybersecurity perspective, whatever information I do not collect, I do not have to protect. Other way around, all of the information I collect, I should protect. Which basically means my job will become much harder as we collect more and more information. So the limitation of collection, which basically says only collect information if people consent to it and if they know about it, helps us out in terms of the volume of data that we have to protect. The Data Quality Directive talks about the nature of the data that you're collecting. So not necessarily about the fact that you need to have consent, but what is the information that you are collecting. And the conditions there are, well, it has to be relevant to, for whatever reason you're collecting it, and it has to be accurate, which means that you should limit as much as you can collecting incorrect information, but you should also put efforts towards maintaining the information after you've collected it. There is an individual participation, which is related to the collection limitation, but basically says an individual, down to the individual person level, must know exactly what data has been collected about them. So not just a category of data, but what that data says, and they must be able to access it. So under the OECD guidelines, I must be able to go to a company and say, hey, show me what you have about me. And that company should comply if they take privacy seriously. When information is collected, it should be done for a purpose, but that purpose also needs to be known. We need to be able to explain why we have this information at all times. And that is the only reason that we should be collecting information for. So for example, if I am making a hotel reservation and they're asking for my telephone number, they can call me to talk about my reservation, but they should not be using it at that point to drum up additional business. That was not the purpose for which it was collected. That is not something that I consented to. So from a privacy perspective, the use of data must be in line with what the person consented to and what the intent of collection was. We must protect the data. Again, the more data we have, the more we need to protect. And that has to be reasonable, whatever that may mean. And it has to be open, and that means that individuals must know who's collecting it, but also have a way to contact them. So I should be able to contact any organization, and it should be clear for me who to contact if I have questions about data that might be collected about me. And then lastly, accountability is a key aspect through everything. If I cannot hold anyone accountable, it's not going to happen. So accountability is one of those lessons that you will always have to keep in mind. You might be setting new policies, you might be setting new technology standards, but if you're not going to hold people accountable for the use of those technologies or for compliance with those policies, they are going to be mostly ineffective. So these are the 8 principles laid out by the OECD. The EU goes further than what OECD suggests. The EU General Data Protection Directive is a little different the way that the EU deals with laws and regulations than what the United States does. In the US, you can set things at the federal level. In the EU, it still has to be approved by all of the individual member states. But a lot of these principles that we just saw are represented in there. So we have to have notice, which means that I must tell you when I'm collecting information about you, and you have to consent to me collecting and using that information. I can only use it in the way that I said I would use it. I should be able to access all of my data, but I also should be able to delete any data that you have about me, the right to be forgotten, so to say. So I should be able to call up an organization and say, remove all information you have about me. And they should comply with that. I should be able to correct any factually inconsistent or incorrect data. Now, whether I do that by replacing data or by annotating existing data, under the EU GDPR, the General Data Protection Directive, that should be possible. I must secure it. And I have a clause called onward transfer, which means that if I share your information with someone else, I have to make sure through contracts or through other mechanisms that they protect that information to at least the same level of security as I would have done it myself. So I cannot just collect information, promise I would not do anything with it, and then sell it to someone who could. The onward transfer clause talks about that. And lastly, we have enforcement, which means that an individual has the right to enforce privacy law, which means that if I feel that my data is not being treated in accordance with privacy laws, I can file a complaint as an individual. It's not something that the government has to do on my behalf. Now, GDPR is a fairly recent law that came into effect in the EU. It was meant to bring privacy laws into the modern era. And it added to the requirements we just saw with additional requirements, such as if there has been a data breach of PII, personal identity information, companies now have to tell the individual people within 72 hours that this happened. That is, or at least that they become aware of it. That's huge. That's something that didn't exist before. I mean, many companies have either never disclosed data breaches or sat on it for months and months and months out of fear of, for example, liability suits. EU GDPR says, no, if you don't do that within 72 hours, you're breaking the law. So that is pretty aggressive. It explicitly gives subjects the right to access their data, which includes being able to modify or delete it. The data must also be portable, and that means that if an organization is collecting information about me, I can go to that organization and say, give me everything you have about me, and give it to me in a way that I can actually use it to do something meaningful, and you cannot charge me for that. That's very different than in the United States. In the United States, those records are owned by the persons who collected them or who compiled them. And the individual who's being described in that data really has no rights to it. Under the EU GDPR, that's different. If you are collecting information about me, I have at least as much right to that information as you do. We have the right to be forgotten, and maybe even more importantly, privacy must be designed into the system. So every design decision that a computer scientist or an information systems specialist makes, wrong button, should account for privacy in their design, in their decision making. It's not something you can say, okay, let's build a system and then afterwards we come back and design privacy in it. It will never be as effective when you do it after the fact, and the EU acknowledged that. So it's unusual for a number of reasons. First, it applies to all companies processing data of subjects residing in the Union. And that means that even a US company that processes information about EU residents is subject to the EU GDPR. There's all kinds of complex business laws, but it does allow the EU to set restrictions on what non-EU companies can do with information as long as it is about their subjects. Now, it's also a law that talks about residency, not necessarily about citizenship. GDPR has significant teeth. If you breach GDPR, you can be fined up to 4% of your global annual revenues, or 20 million euros. And then the caveat is whichever one is greater. So there's basically a lower cap of 20 million euros, which can go up if the company makes more money. That is a lot of money regardless of who you are. 4% of your annual global revenue, that hurts. That is a good motivator to do the right thing. And that because of GDPR, and people have to be reasonably able to understand what is being done with their data, it's now no longer possible to have these volume-long privacy policies which are written in completely dense legalese and no one understands what's in them. The GDPR basically says it has to be in human-readable, easily understandable language as well. Clear and plain. It must also be possible to withdraw consent after you initially gave it. So there's a lot of protections built into the GDPR that are not built into other laws, especially the ones in the United States. In the US, there is no comprehensive federal privacy law, but there are some states who are working on it. California is the most advanced with their CCPA, the California Consumer Privacy Act. It's very similar to what GDPR says. You have to know what data is being collected. You have to be able to know when it's being sold or disclosed. You have to be able to opt out of the sale of personal data. Now, all good and nice. Privacy advocates will say, why do I need to opt out? I would much rather have to say, okay, I have to opt in, but take what we can get right now. Disclaimer though, CCPA only applies when you have an annual revenue over 25 million US dollars, if you process more than 50,000 records of PII, or if you earn more than half of your revenue by processing PII. Personal identity information. So there's a large number of companies that are not subject to the CCPA at the moment. At some point they will probably come into scope, but they're not there yet. I briefly mentioned at the federal level in the United States there are no comprehensive privacy laws, although there are several laws that have privacy components to them. The most important and the most recognizable ones are the ones listed on the slide behind me. The Privacy Act of 1974 regulates how government manages PII, so that's a very old law that in terms of 1974 describes what can and cannot be done. financial sector, banking, has pretty strict rules and regulations about what information you can collect and how you need to protect it. Credit reports, like the big 3 credit bureaus that had the data breaches a while ago, at least one of them, have their own regulations. Healthcare through HIPAA. For us in higher education, FERPA, the Family Educational Rights and Privacy Act, there are some rules that protect children under 13 years old, although that's mostly California-based, and electronic communications. But all of these are point solutions. There is no US federal law that enshrines the right to privacy in any form of legislation, unlike the European Union, where that is being done.